Okay, we have, I think both of our counsel are here. Are we all hearing one another?
Yes, Your Honor.
Okay, then this will be the first case on our docket today. This is Hires versus the state of Florida. Attorney Reese, I believe you represent the appellant. Did you wish to reserve any time for rebuttal?
Your Honor, if I could reserve 2 minutes of time.
2 minutes. Okay, I've noted that, and I will try to let you know when you get to 18 that you are or probably slightly before 18. That way, if you want to sum up, you can still have the full 2 minutes.
Great, thank you, Your Honor.
Okay, and I thank you. You may proceed, counsel.
Thank you. May it please the court, counsel. My name is Rachel Reese and I represent the appellant in this matter, Morris Hires. Mr. Hires was an 18-year-old young man when he was charged and later convicted of 1 count of second-degree murder and ultimately sentenced to serve the remainder of his life in prison. His arrest came after a young woman was unfortunately shot, the victim in this case, Felicia Vickers, while she was sitting in the back seat of a vehicle. Ms. Vickers and 4 other individuals had gone to the scene of the shooting with the intentions to participate in a drug deal. After a dispute arose during the drug transaction and shots were later fired, she became the unintended victim. After law enforcement responded to the hospital and took statements from the individuals from the vehicle, Mr. Hires ultimately became a suspect in this case. However, from the very beginning of their investigation, it was understood that Mr. Hires was claiming an alibi. Both Mr. Hires' mother and himself, when he ultimately did speak with law enforcement, advised them that he was not at the location of the shooting, but however was at a nightclub called Club Scene. Mr. Hires never wavered from this theory. However, himself and his attorney, Benjamin DeBerg, were led to believe that this theory could not be corroborated because the video surveillance from Club Scene was of poor quality after law enforcement had gone to—
On the point of the video, counsel, I'll ask you this, and I think for the state to respond. Assume for the purposes of my question that the failure to investigate the existence or the non-existence of the video meets the first prong of Strickland. Tell me about the second prong, if you will, of Strickland. Why, if there was no video there, how that result might impact on the second prong to give us reason to doubt the appropriateness of the outcome.
Your Honor, that's a very good question. And unfortunately,
It happens occasionally.
I don't think that the answer is very straightforward, unfortunately. And the reason for that answer is because I think that the ineffective claim has kind of become grouped in with this new Giglio claim because the video does not exist. So we cannot prove what's on it.
We don't know that it doesn't exist. It doesn't exist in our record. That's correct, I believe. I didn't see anywhere where it said it doesn't exist because someone went to Club Z and asked. There's testimony that suggests that in the past, Club Z was less than forthcoming. And the reason I asked that about the second prong under Strickland is my understanding is your client would bear the burden of persuasion on both prongs. And if your client fails on either prong, then the appropriate result from our court would be to deny relief. And so right now, I'm interested in that, but if there's nothing further, I don't want to belabor your point and take up the rest of your time, but it is his burden of persuasion.
No, of course. And I believe at the beginning of the evidentiary hearing, the assistant state attorney who was handling the case acknowledged that the video did not exist, that it was nowhere within their file. And obviously at that point in time, 8
Again, that's
years
not
had
in
passed.
your record. There's a difference between never existing and never being in the care and custody and control of the state or the defense or anybody else. And my concern is if you have a counsel who's told there's a video and does investigate to find out if the video exists, had they done that, then there would have been an interesting dynamic. Why didn't this, might have corrected the state's problem before trial. We wouldn't have had the issue you raised with the argument. Might have, in fact, found cross-examination very interesting. Or if there was a video, they would have looked at it to see what it in fact said and put it on the witness disclosure under 3.220. So I'm concerned that there's a lot of permutations from this. But I also know, having reading the stuff, the state makes a very persuasive argument under, I think, the Gigo issue of the extent of the evidence against him. And I want to get the response. Why does prong 2, why should we conclude that your client has met the burden of persuasion? And I'm asking you to assume one, the other panel members may not be that way, but I wanted to focus my thought on that question particularly.
Absolutely. So in regards to the failure to investigate under that second prong, obviously, as Your Honor said, there's no video in the record. I think that's where the issue of the lack of obtaining the video and consistently having the video on the state's part, as it was something that was completely relevant, I think that that's where a negative inference should not be held against Mr. Hires, as it would have literally been impossible for him to meet that burden by the time he came back for his post-conviction motion, because the video at that point in time no longer existed. And I think that's where I believe that we cited a case in our reply brief, it's State versus Ellis from the 3rd DCA, and it was not an ineffective issue, but it was an issue about the failure to preserve evidence, and how if there's a chance that it could be exculpatory, that shouldn't be held against an individual or a defendant in a negative light. And although that's not the norm with a Strickland issue like we have here with the failure to investigate, I think that that is something that is very persuasive, because no matter which way you look at this issue, it all surrounds this video, whether it was an ineffective counsel claim, a Giglio claim, originally it was raised as a Brady claim. The reality is that nobody's disputing the video is not
counsel. Here's an obstacle I'm bumping up against, and I think I'm starting to get my arms around existentially what that argument is. But I've got a fact finding here in the order that's under review, and I'll just read it. And granted, it's in the context of that it can't establish a Brady violation occurred, but it's a pretty broad fact finding that the post-conviction court makes. It says, first, the court finds that the videotape never existed. What do we do with that in light of the arguments that you're making?
I think that the way to handle that is that unfortunately, it's our position that the fault lies on the state and the agents of the state attorney's office, that whether or not they believe that somebody had gone and secured this video, nobody ever did. And that's where this issue becomes, that's
not what this finding says. This finding says the videotape never existed. In other words, whatever these two detectives were talking about back and forth about, you got the video? No, you're getting the video. Doesn't matter. According to the post-conviction court, there's a fact finding here. There never was a video.
And I think that's important, Your Honor, because that leads us to the point of then any conversations about a video are undisputably false. There is no video that ever existed based on that finding. And I think that finding supports the Giglio issue a lot more, because obviously there is no video. How can Detective Harper have sat in front of a jury of Mr. Hires' peers and told them that a video existed? It did not corroborate or refute his alibi. Instead, we just couldn't do anything about it. So
if I understand your argument, then it's a couple of steps that you got to link together, but the steps are there. Take the post-conviction court's fact finding on its face. There never was a video. Defense counsel should have investigated and confirmed there never was a video. And when the detectives got on the stand during trial to talk about basically an issue that, yeah, we looked at a video, there wasn't anything there, they would have had basically some collateral impeachment evidence to work with to impeach these detectives' credibility based upon the fact that they said that there was a video they reviewed, but it was bad quality, versus no, there just wasn't a video. And that would have been such a key piece and a key moment in that trial that we have to doubt that the verdict was properly obtained. Am I getting that more or less right?
Yes, Judge Lucas. And I think that kind of piggybacks on what Judge Casanueva was saying earlier, is that, this issue with the video and how it was portrayed, this could have been dealt with before trial. It may not have even become an issue of impeachment. It would have been an issue that this would have never been brought up. It could have been an issue where they argued, law enforcement didn't do an adequate investigation. They knew about this potential alibi and they never secured a video. obviously, based on what we heard from the evidentiary hearing, the detective first never was told to go. He never went, and he never secured this video. So that could have been an argument that Mr. DeBerg could have made at the trial, even more so than just impeachment. But the negative implications that came from the argument and the testimony that was presented about the, you know, the blurriness or the inability to confirm or deny Mr. Hires' alibi because of this video, the negative connotations that came with that were huge. So I think that if the issue through the steps, whichever way you look at it, had the video not been mentioned or had it been used in a positive manner, that is our argument, that that would have been enough for Mr. Hires.
Ms. Reese, I guess I'm following your argument on the Strickland. I'm not sure that I'm quite there, because if we look at whether this affected the fairness and the reliability of the proceedings such that the confidence in the trial would have been undermined, we have to find that, but for this attorney error, that the result would have been different. And we have overwhelming evidence here as far as the eyewitness and other record evidence in this case, such that how is it so that this error by the attorney and failing to investigate the video would have changed the result in this case?
Absolutely. So the video, the failure to investigate, obviously, as your honors have said, if it had been investigated, then they would have known obviously ahead of time that no video existed. The comments that were made would not have been able to be made. So obviously those negative connotations would not have been present. But in light of the other evidence that was presented, the other evidence is actually not as overwhelming as I believe it was portrayed in the record. I believe even Detective Harper testified at the evidentiary hearing that there was no physical direct evidence that directly linked Mr. Hires to the crime scene. Obviously, there was no DNA, there was no fingerprints. He said that the only reason they even went after Mr. Hires originally was because of the statement of the one witness, Kenneth Chris, who ultimately did ID Mr. Hires, and he was the only person who identified him. The other four individuals who were present in the vehicle, obviously excluding the victim, they all eventually testified at the trial, but nobody except for Mr. Chris could identify Mr. Hires. So the only person that identified him, he had the shakiest identification. I believe the court had to ask him several times about physically identifying Mr. Hires in court. He identified Mr. Hires as a shooter, but then he actually even backpedaled and saying that he, quote, believed it could be Mr. Hires, but he didn't actually see the person's face when the muzzle flash went off. He couldn't say. He couldn't remember what Mr. Hires was allegedly wearing at the time that he approached the vehicle, and then later went into the residence and came back out to shoot. And most importantly, he could not recall originally telling law enforcement officers that it was an individual named Unk who had approached the vehicle, and an individual named Unk who had gone back into the residence and come back out and started shooting, which the significance of that, as testified to by Mr. DeBerg, was that Unk was Mr. Hires' uncle, who had also been involved with this individual, Mr. Chris, and had sold him drugs.
Don't we have the same type of ammunition that was found in Mr. Hires' room that was involved in this murder?
There was similar ammunition found in the bedroom where they alleged that Mr. Hires was staying. However, there was also testimony that several other individuals in that residence had access to that room. It wasn't just something that Mr. Hires solely had access to. There was also ammunition found in a shed behind the residence. The other evidence that they used to argue circumstantially that it was Mr. Hires was obviously the cell phone and the cell phone towers that linked the cell phone to the crime scene, but the cell phone itself was never actually physically linked to Mr. Hires, and instead an adequate explanation about the buddy phone and the buddy phone being used in drug deals, which again goes hand in hand with that same theory of defense that it wasn't Mr. Hires, it was his uncle that was involved with this. The only other, again, all the evidence continuously comes back to this one individual who was a 4-time convicted felon, crimes of dishonesty, offered to change his testimony if Mr. Hires' family would pay him money. Obviously was not the most credible witness. So without something directly tying him, the fact that Mr. Hires' alibi was presented to the jury as something that he possibly made up after the fact, which in the state's closing argument, the state specifically makes that argument.
You're referring to the Walt Disney state?
The Walt Disney statement, yes.
And there wasn't, I didn't see any contemporaneous objection by counsel.
There was not any contemporaneous objection. That statement was actually made as a question during the examination.
Yeah, and I don't even think, when I looked at it, I don't even think that it was actually answered by the detective. I think the detective went into something else and answered another question, but I don't think it was answered. Okay, so I think I understand what your Strickland argument, but I'd like to go to your Giglio argument. And let's say we assume that the testimony by the detective was false. We also have to find that the prosecutor knew that this testimony was false. And I believe that your argument is that the prosecutor knew or should have known, but I'm struggling with finding evidence in the record where this prosecutor knew or should have known, other than what you're saying is that they should have investigated. And
I think the easiest answer to that question is the precedent that says that the state and its prosecutors are held to have the same constructive knowledge and possession of evidence that their agents have, which in this situation would have been the lead detective, the lead investigator on this case with the St. Petersburg Police Department. And there's a couple of cases that I think are kind of instructive on this issue. The first one is the Guzman versus State, which I believe we cited in our reply brief. It's from the Florida Supreme Court. In that case, the defendant claimed that both a lay witness and a detective had testified falsely at the trial by saying that the informant hadn't been given any additional benefit for testifying. Come to find out, the informant had been given a $500 benefit. And the court found that, number one, both witnesses, by leaving that testimony out or saying that there was no additional benefit, had testified falsely. And then the court specifically found, and I just want to quote it so I don't misspeak, that the state had knowledge and the knowledge element had been met because the knowledge prong is satisfied because the knowledge of the detective who paid the reward money to Cronin is imputed to the prosecutor who tried the case. Now, at first,
Counselor,
obviously,
you're at 17.
Thank you.
You're at 17.
At first, the initial reaction is, well, we don't know in that situation if the prosecutor had been told about this issue ahead of time. However, in another case, which is the Gorham versus State case, which was another Florida Supreme Court case that was cited, I believe, in our initial brief, it was a Brady issue. However, the Brady and the Giglio issues go hand in hand because the knowledge requirement is there for both of them. It's just knowledge about different things. It's knowledge about failure to provide evidence or knowledge about false testimony. So in that case, the court specifically found that the knowledge element had been met, and it said because, and this is a quotation, even though the police did not reveal Johnson's informant status to the state attorney who prosecuted the case, the state attorney is charged with constructive knowledge and possession of evidence withheld by other state agents. And the reason that's important in this situation is because that court specifically found that even though the state attorney wasn't told about that specific piece of evidence, the state attorney has an obligation to the state of Florida, essentially, to seek justice and to seek the truth and to follow up with their witnesses, especially the lead investigator. And that's the same in this situation. The state had knowledge by the law enforcement officers having knowledge of this false testimony. And I see that my time.
I don't think there that the trial court found that the detective was, I guess at the time he testified at trial, that he knew that testimony was false. I don't see that in the record. It seems to be more that he was mistaken at the time and now has later learned that what he testified to wasn't exactly accurate. And so those findings, I don't know that we can disturb those findings by the trial court.
And I believe the trial court found that the testimony of Detective Harper at the trial was false, because I don't think that you can dispute that obviously there was no video and he testified to that. And I'm citing to the record, it's on
trial court. Okay, but the trial court didn't find that at the time he testified, the detective knew it was false. I think there's a distinction.
I would agree with that, Your Honor. And I don't think that the distinction is something that the court has to find. I think that the issue is not necessarily what Detective Harper knew. It's just a blatant fact that his testimony was false. And because it was false, somebody else at the law in their community,
right. I think that goes to the first prong, but I think what I'm following on here is the second prong, that the prosecutor knew it was false. So you're saying that the detective's testimony, even though he believed it to be true, the prosecutor should be charged with knowing that the testimony was false. And
Judge Casanova, I see that my time has expired. May I respond to the question briefly?
Please.
Thank you. And I thought long and hard about that exact question, because I couldn't wrap my head around all these different layers to this one specific issue with this video. And the reality is, I think that it's a lot easier. It's the issue that Detective First was never questioned by anyone. He was an equal member of law enforcement during this entire investigation, that the state attorney's office had an obligation as one of their agents to reach out to and confirm this hearsay statement that was included in the report, the depositions, the fact that nobody ever followed up with the one detective who could have attested that this was false, that he never actually physically went and got the video, never had these conversations with him. That is the knowledge that is our position, that the state attorney's office is charged with having the constructive knowledge of, because he is equivalent to Detective Harper, and St. Petersburg Police Department knew that this did not exist, and somebody knew that this was false testimony being presented. And for those reasons, I would ask that the court vacate the trial court's order and provide Mr. Hires with a new trial. Thank you.
Thank you. Okay, we will move on to Attorney O'Neill on behalf of the state. And I see you have unmiked. Thank you very much.
May it please the court, counsel Kelly O'Neill for appellee of the state of Florida. I'd like to just jump right into the Giglio claim if the court is okay with that. So the state's position is that there was no Giglio violation in this case, and largely because of the conversation that was just ongoing, is that the defendant failed to establish that the prosecutor knowingly presented false testimony. And the trial court made that finding, essentially saying that we didn't learn until the evidentiary hearing that this was even the situation. So the prosecutor can't be charged with that knowledge at the time of trial. As to the claim—
Let me ask you this. What the trial judge is finding is that the state, in working up the preparation of their case, never found before they put the witness on the stand that they were not in possession of a video. So what we're saying is that the state's assistant state attorney was ineffective in preparing their case, because a competent lawyer would have found out that there was a piece of evidence that they didn't have and would have notified people before the trial started, because there's a continuing duty to disclose under 3.220, is there not? So we're saying is the state didn't know it or didn't want to know it?
Well, Your Honor, respectfully, I think that the state didn't know it, and that I think a fair reading of the record is that there's a little bit of ambiguity between whether there was ever surveillance footage that existed or whether there was a physical video. And unfortunately, everybody used the same word video for everything. And so I think it could be read that someone went out to look at surveillance footage and they couldn't find anything that would be of any merit. So nothing was ever collected to be a hard video. Now, I'm not really sure that the prosecutor should be charged with knowing, or I guess in response to your question, I don't think that.
Are you telling me, or I shouldn't say you telling me, that's incorrect. Did anyone inquire in the record of this proceeding whether before trial the state interviewed and prepared their witnesses? Because one would think if they are preparing their witnesses, they would ask the witness about the video. Now, if no one asks, then there's nothing in this record that we can look at. But it would seem that if the state is getting ready to go to trial, they would interview their witnesses and find out what knowledge they have. Unless the record suggests they put them on cold.
No, I would not suggest that. And there was a deposition of Detective Harper prior to trial. And in that deposition, defense counsel.
So arguably, counsel for the state could rely upon that in lieu of a live preparation or interviewing of the witness. At least that's what the record would show.
Yes.
Okay.
As to the claim made by appellant that the knowledge requirement under Giglio was met because of the detective's false testimony, the state just responds that no, as Judge Smith pointed out, excuse me, the prongs are separate. The first prong is that there's false testimony, and the second prong is called the knowledge element for a reason. There has to be some sort of knowledge, and it's clear from all of the record that we have that the Detective Harper, he even sort of qualified his statement. I never watched the video. I never saw a video. First went, and from the best of my recollection, from what I believe, from my understanding and my discussions with him, was that this is what the video showed. And so even at the evidentiary hearing, he was adamant that that's what I believed at the time. I testified that way because I specifically thought that we had obtained the video. I specifically thought and believed, based on these conversations, that that was my knowledge at the time that I testified at trial.
So the distinction I think that Judge Smith was asking counsel for the appellant, I think it's also appropriate here, is the state's argument is there is a distinction in the case law between a mistaken testimony or an inaccurate testimony that can be challenged by cross-examination and a false statement, which is the functional equivalent of a perjured statement.
Yes, that's the state's position, is that because the whole purpose of it is to prevent, the perjured testimony from being elicited to the jury. And so I can't imagine that anytime someone was mistaken about something that it would wind up being a Giglio violation, or that the prosecutor was then imputed with that. I don't think that that could be the case, or that's the standard.
Then would we follow that reasoning into the Strickland context? Because had counsel for the accused investigated and found no video, no tape whatsoever, would that have been a potent tool on cross-examination of that witness to point out that they were mistaken, that there was no video, that those things just didn't happen?
I think that would have been a good point on cross-examination, but at the end of the day, the state's position is that there was no prejudice here. And if the court—
The state's position is prong 2 has not been met, and you only have to prevail on one prong.
Yes, and if the court would allow me, I would just like, because I didn't have the benefit of the full underlying record at the time that I wrote my brief, if I could just do a 2-minute synopsis of what the summary of the trial transcript would show.
Go right ahead. It's your time, and you are way far from 20.
Okay, great. Thank you. So the evidence at trial was substantial against the defendant. Casey, the main witness, indicated his familiarity with the defendant over the prior year through 75 to 80 drug deals. He identified the appellant as the shooter. 3 hours after the shooting, he identified the defendant via a photo pack and said, in quotes, "That's him, 110% nephew. He shot at the car." This is on pages 220, 226, 228, 232 to 238, 245 to 247, 254 to 256, 270, 333 to 334, 489 to 490, 492, 494, 526 to 530, 535. All of the other witnesses that were interviewed by law enforcement corroborated Casey's version of events. So even though those witnesses weren't able to identify the defendant as the shooter, they all specifically told the same exact thing that lined up to and corroborated Casey's version of events. So, and that identified that they knew Casey was dealing with a person named Nephew, and that they were going to Nephew's house to do this drug buy. This is 179 to 181, 184, 186 to 187, 333 to 334, 342, 344, 534. The cell phone records between Casey and the defendant established their call logs leading up to the drug deal. The tower locations established the defendant's phone in the vicinity at his residence during all of those calls, and that it was not near downtown St. Pete. 228 to 229, 350, 528, 558 to 577. The calls also reflect a total of 13 calls between Casey and an appellant that night. The defendant, although claiming that other people had access to this phone and that it was a buddy phone, admitted that he regularly used the phone. It was linked to him through the phone being given to his mother by her friend years ago, and that he acknowledged that he had the phone number recited from memory, and this was 6 weeks after the murder occurred. This was 314 to 316, 549 to 550, 553, and 554. The bullets found outside of the crime scene match the same bullets found in the defendant's residence amongst his personal belongings. These bullets were found right next to the defendant's birth certificate, his social security card, and mail addressed to him that had his name and address listing him at that residence. This is 367, 372 to 73, 376 to 77, 406, 409, 412, 433 to 434. And then we have the consciousness of guilt. After Casey called the defendant and told him that he shot and killed this victim, by the time the police went to the residence 3 hours later, the defendant was gone. He fled for 6 weeks from law enforcement. The phone that he had used had never been turned on again, and he was eventually apprehended hiding in his home with the assistance of U.S. Marshals, 547, 549, 589 to 604. So the state's position is that regardless of any deficiency on counsel's part, and any collateral impeachment that would have come out about this video, there's no prejudice that the defendant suffered because of the significant amount of evidence that incriminated him and it linked him as the shooter in this case. If the court has no questions about ineffective assistance of counsel, I believe that I had mentioned that the trial court found that there was no prong two hadn't been met about the knowledge requirement, but also I just wanted to note that the trial court also found that the testimony was not material, and they found essentially because it was neutral to the defendant's alibi. It didn't say, oh, we checked the video and he definitely wasn't there. It was just neutral. The testimony was that he could have been there, but we're not sure. It didn't say he was there. It didn't say that he wasn't there. And so the trial court's finding on that was supported by the evidence that was brought out at the hearing. But also I just want to say that this testimony was not a feature of the trial in any way. The testimony at trial came out with 14 different witnesses, over 500 pages of transcript, and the testimony about the video was not mentioned in openings. It was mentioned once in closings by each party, like through one sentence statements, and it was mentioned over 5 pages of transcript in the questioning of 2 different detectives. This was not a feature of the trial. All of the aforementioned evidence that I cited to just before this were the features of the trial and what the state really argued as what was incriminating the defendant. So based on that position, the state contends that the trial court's findings on the Giglio violation and the ineffective assistance of counsel on the video claim are proper and should be affirmed. And if the court has no other questions on the remaining claims, I would just rely on the arguments in my briefs.
I don't see any questions from the panel members. That being the case, I thank you for your presentation. And for the appellant, I know we used your time, but I'll provide you the 2 minutes to respond to the arguments raised by the state in their presentation.
Thank you, Your Honor. Just a few very brief points. The first brief point, I believe that the state was asked about the physical presence of the video and the fact that somebody was asked to go out and look at the surveillance video and they just didn't actually get a copy of it. I think the record shows differently than that. The Detective Harper was specifically asked if he could have been mistaken about who he asked to go look at the surveillance video. He said, absolutely not. It was Detective First. Detective First said, I was never asked. I never went. So it's our position that the record shows nobody ever went to see that video. So there was never an opportunity for the video surveillance to be put on a physical video. The next point was in regards to Judge Smith's point about whether if it's just a mistake in testimony, if that's enough for a Giglio issue. The reality is that this was not a mistake. This was an issue that someone from the state attorney's office, their agents, the St. Petersburg Police Department, and somebody had the information and failed to diligently seek the truth. And in doing so, they presented something that was blatantly false to the jury in Mr. Heyer's trial, which leads to my final point. During the state's closing argument, their rebuttal closing argument, which is the last thing that the jury heard in this case, I think it's important to just, and I'm just going to quote exactly what was argued because I think it's important. The state argued, and that's on page 716 to 717, ladies and gentlemen, he gave the police an alibi that could not be verified. I was at a busy club, a club that they pulled the video for, and there was no video. The detective told you that they got the video. They looked at the video, and it was of such poor quality, you could not tell anything from it. And they want you to think that that's reasonable doubt. It's not. Witness testimony is evidence. They reviewed the video. He said, well, you could have shown it to my client. Ladies and gentlemen, he only came up with that story about the club after he was hiding in a crib and got bit by a dog, a police canine. And I think that's important because, again, that's the last thing that the jury heard. They're being told that this alibi is made up. And had this
Thank you.
been
I think
investigated,
that's the end of your time.
may I briefly
You're going to
close,
ask
Your
us
Honor?
to reverse, right?
Yes, Your Honor. If you would reverse the trial court's order and with directions for Mr. Hires to have a new trial. Thank you very much.
Thank you. Thank you both. Well presented. I appreciate your working on this case. Thank you very much.
Of course. Thank you very much.
You exit.